Some people watching might be able to identify with any of these examples or might have been experienced that either from a professional position acting as a lawyer or an advisor or perhaps as a client or just a lay person in the situation. The first one that appears quite commonly is defective products. You've got consumer and business accountability. If a product injures someone, what's the legal pathway in plain terms? So, often it can be framed under the Australian consumer law, consumer guarantees, safety representations, plus negligence. It can become multi-claimant, group style disputes if the product is widespread. And the kind of evidence that you might need is, product IDs, batch serial numbers, purchase proof, medical links, recall notices, if any. This is a common one that arises.
Correct. Correct. And it would still be, again, the same proceedings, but you'd have multiple defendants involved because of the contractual relationships between each of the entities. For instance, right now we have a case where our client bid into a pistachio and, bought a pistachio product from a grocery store. And unfortunately, there was a piece of stone that was within the bag and she's bit into it and has suffered some serious injuries. Now, in that instance, we are pursuing the claim under both the consumer law as well as the Wrongs Act legislation. We are suing both the manufacturer of the product as well as the company, the grocery store that was selling that product.
And that would seem to me to be most appropriate path. So I'm sure that the client's in very good hands there. And the second example I'd like to highlight is injuries on business premises. Very common to you, Sash, you know all about it. Slips, trips, falling on objects, the classic, I slipped at the supermarket. What actually matters legally? From my perspective, and I'll let you comment, but from my perspective, it's you got issues around reasonable safety systems, inspection, cleaning, warnings, and these claims are usually run against the occupier of the business and handled through public liability insurance. And evidence that I see that's important is often incident reports, CCTV photos, witness details, medical records, and I'm sure you've had more than a couple of those in your time, Sash.
I certainly have in the last 16 years, Michael. One recent one involved a client of ours who was walking from her parked car to the place of employment. She was working at this particular premises, but her employer was actually a labour hire company. And so she has a trip and fall on this the residence of the commercial premises of where she worked at, and so she ends up suffering a nasty elbow injury. And when it came to her common law claim, we had to name her employer, the labour hire company, the occupier where she worked at. We had to name the entity that owned the building premises, the commercial premises. And unfortunately, there were a number of entities involved, including who that big premises was leased from. So we needed to name the landlord and whoever was on title, because whose responsibility was it to maintain that crack where our client slipped and fell? The employer had this non-delegable duty. It's the occupier where she worked at. It's their premises that she's required to attend. So what responsibility did they have even in notifying their landlord that there was this crack that their workers could potentially trip and fall? And then from that landlord, which entity did they lease from? So it was very complex, and it again a case where we had to issue proceedings.
And that segues into the next point. Work sites and third-party workplace injuries. We know work cover exists. So when does it spill into broader litigation where multiple entities are involved? Principal, contractor, subcontractor, site controller, equipment supplier, site owner, lessee, lessor. Often you see one injury, several businesses, big insurance contribution disputes. We've touched on this, and it really highly relevant to the case that you
Yeah,
just gave us some information about.
it's right on point, isn't it, Michael? Unfortunately, I don't think it increases the injured individual's entitlement to damages, but we plaintiff lawyers, do like it when there are multiple defendants because typically, if everyone does cooperate, we can potentially extract a bit more for our clients. And the cost thresholds that are typically applicable in workers' compensation damages trials, not so relevant when there are multiple defendants.
Yeah, and that's all part of the case strategy, and that comes from experience, Sash, your 16 years of excellent experience that you're bringing to the community and the people of Australia.